Hey everybody, we're week 4. We're going to talk about juvenile courts this week. Last week your written assignment was on 3 strikes. After Prop 36, I mean, a lot of the noise has died down on that particular issue. But what I wanted you to get from that is the idea of the balance of crime control and due process, and where at any particular time we're putting our societal emphasis. At the time of the initiation of the 3 strikes rule on the federal side and then subsequently on the state side, the concept was that that crime needs to be controlled, and incapacitation and specific deterrence are the ways that you achieve that. Ewing, the other thing I wanted you to get from Ewing, and I don't recall seeing that on a paper, is the idea that when you look at some of the facts of these cases, depending upon which side you're on, they get distilled, they get drilled down. Here, he took 3 golf clubs. The value of each was less than grand theft. It's $399. My goodness. Well, let's look at this from a different perspective. First off, he took three items, each less than $400, for a grand total of well over $1,000. And that was in the money of that, what was it, 1994, I think the case was. So that was a pretty good amount of money. And he came in and stuffed them down his pants. Now, during that time frame, one of the things that was very popular to do was to break into the golf stores. You had a lot of freestanding golf stores or pro shops at golf courses and steal golf clubs and then take and sell them on the open market, and you could make some pretty good money off of that. Ewing does not sound like a guy that decided that he needed the newest Callaway Big Bertha to help control a slice. He was probably, they don't go into it, but I wonder if he had the money for the items or any money at all. In what he did in the store to help prove whether or not he entered with the intent to steal. When you get to 340, you'll see that entering into a specified structure with the intent, not committed, but only the intent to commit a felony or theft therein, is burglary. So even if the golf clubs were $399, in that day, prior to Prop 47, in that day, that was felony burglary. They only charged him with grand theft. Not quite sure. My only guess is that they didn't feel as though they had enough to prove that intent issue from burglary. So it's a little bit different than what we see, than what you see, and that's an important thing as you look to judge, what's going on in a particular case, a particular policy decision. How is it put together? How is it given to you to decide? An example of this same kind of thing would be Prop 47. That was titled the Safe Schools and Streets Act of 2016 or whatever it was. It has nothing to do with schools, nothing to do with safety. It's about lowering the threshold, or I should say raising the threshold for a felony. The purpose? So that we have fewer people in prison. The result? I don't know. It's when it comes to commercial burglaries, no matter who does it, no matter their method, how they do it, if the value is less than $1,000, then it's a release on a citation crime. It's a misdemeanor and must be released under 854.7 of the California Penal Code. Cite and release. The working cops that I know call it catch and release policing. So understand that You can't take that stuff on face value. Okay, now for this week, let's talk about juvenile justice. Prior to about the 1890s in the United States, juveniles were considered to be just small adults. So if they committed a crime, they were treated like adults. They went to adult court and they went to adult jail, frequently with a really, really bad outcome. So 1880s, 1890s, you started to see the development of at the time, they called it a progressive movement in politics, in several different social areas of the American culture. And one of those was a group who identified themselves as the Child Savers. What the Child Savers did is they tried to change the approach to juveniles and suggested that, incomplete development, their how they are dealt with, their development, they're not miniature adults. They're not little adults. Now, from that, just prior to that, you had Enright Krauss, which was a pretty cool case with a girl. Mom and dad were split, 1839 and 38. That's pretty interesting. They were split. Marianne Krauss ends up living with mom. She goes out and starts doing some ghastly criminal activities, such as going dancing. So my guess is that she was really young. She was like 13. But on one hand, the potential for victimization is sky high for a 13-year-old in a bar. However, the police and the courts became involved, and then she was hauled in front of the court to answer the delinquency charges. Dad shows up and says, "Hey, look, I'll take care of her. I'll make sure these kind of things don't happen." The court came forward with this doctrine of parens patriae, meaning that the state will act as the parent. Then the progressive movement really gets going. The Child Savers really start working on various areas of society, trying to make an impact. And one was in the court system, juvenile court system. 1899, Cook County in Chicago. In Chicago was the first place that you saw a court fashioned for and about juveniles and juvenile justice. That was one of the major things that happened in that process of the progressive states. So modernly, you see basically three times that juveniles come under the purview of the court. The first is delinquency, and when they go out and they commit or do an act that violates statutes in Penal Code, Health and Safety Code, Vehicle Code, Business and Professions Code, when they commit a crime, delinquency. The next are status offenses. Status offenses are crimes that are only crimes because a juvenile has not reached their majority. So, off the top of my head, curfew, I'll go to alcohol violations, possession of alcohol, driving before they have their permit and 16 years of age or whatever that is now. And I say that because it kind of changes and it's getting more and more. I mean, good Lord, back in right after the horse and buggy when I first got my license, I could drive with an adult at 15 and a half. And once I hit 16, well, I'll tell you what, my 16th birthday, I didn't go to school that day. I went straight down to DMV. Actually, I went to school first, and then I left, and my dad took me to DMV, and I got my driver's license. And then I could drive by myself with anybody, all at the great hazard to anybody that was on the roadway. So that's the idea of status offenses. And then lastly, dependency. And that can be anything from both parents have passed away, or parents are not providing care, or parents are abusing the child. And you see, you see that happen, a lot with abuse, where children are taken out of the home. In Orange County, a facility called Orangewood, and it's a protective custody. Next thing I want you to get is the idea that juvenile court and adult court are a lot different. First is the level of formality. The juvenile court is a very informal procedure. However, in adult court, it's just the opposite. Rules of the court have to be followed, very specific. The goal of the juvenile court is to help the child, because we still think of delinquency and the fact that it's a young person. They may be prone, because of immaturity, because of impulse control, to crime, and we want to help guide them through that. And for the most part, that's should be a very big goal. Here's the hard part, is the level of violence we see now in children, in people that are under the age of 18. I mean, horrible violence, and that has to be addressed. Adult court, idea is punishment. You have kind of more of a civil court approach in the juvenile court, and a criminal law approach in the adult court. One big deal is, in adult court, you have the absolute right to a public trial. In fact, there's no such thing as a private trial. Now, public may be excluded when there's certain safety concerns. I was involved in peripherally as defense counsel in a gang case that involved a shooting of a 15-year-old girl, and the judge told the client that none of his friends were to come to court. And the idea is so they wouldn't intimidate any of the witnesses. And that's generally about how secret you get. Juvenile court proceedings are in secret. In the Sixth Amendment provides a right to jury trial. And in McKeever, let me take my notes here real quick. Yeah, I want to say it was McKeever, which was a trial over auto theft, if I'm not mistaken. No right to a jury trial. So, kind of interesting. Some ways that they're alike are the burden of proof, the standard of proof is beyond a reasonable doubt. Came from a case called In re Winship. Very important case. It was a New York case where a juvenile was accused of some criminal conduct, and the court was only required to come to basically a civil standard, kind of back to that old civil law versus criminal law stuff we just talked about. So in Winship, the case went all the way to the U.S. Supreme Court. The U.S. Supreme Court said no, in a juvenile case, the standard of proof is the same as an adult court, which is proof beyond a reasonable doubt. Then and there are some cases that I want you to look at. In Galt, there's a separate section in the book in Red Galt. Kind of a cool case if you have time to pull up and read it. Then you've got U.S. versus Kent, or Kent versus U.S., which is the first U.S. Supreme Court case on waiver laws. So that should get you some of the cases. McKeever, Winship, Galt. Say the cool facts. Basically, said the Sixth Amendment, except for a couple of things, applies to juveniles also. And Kent and Krause. Those are the big cases. Although there's other cases too on death penalty and that are noted in the book that I would like you to have an idea of what goes on. So the book will talk about the different states and when the courts demand jurisdiction over the cases, over the individual in personam jurisdiction. Now, here's probably the biggest controversy, and that's the idea of juvenile transfers. And what a transfer is to send a juvenile case to court. And that's changed in California recently, kind of part of this same due process shift that we're talking about on the overall basis. We're talking a lot about it in policing, but from a crime control model, especially in California, with Prop 36, Prop 47, Prop 57, Assembly Bill 109, Senate Bill 392. See, a pretty large foundational shift, and that was and this whole idea of transfer laws is part of it. So you got a whole slew of things for you to be aware of when it comes to transfer laws, and what you need to know, and that's what a waiver is, what a judicial waiver is, prosecutorial waiver, statutory waiver. When do all of these come into play? What's a reverse waiver? I want you to know that one also. Also, I'm not really big on law names and stuff, but the Juvenile Justice and Delinquency Prevention Act, 1974, another landmark change in the juvenile justice system. And one of the things is that how juveniles are held in custody. First, you can't put somebody in prison for a status offense. So cigarettes is the other one I was trying to think of when I was stumbling before. Juvenile possession of cigarettes. It's a status offense, and prior to 1974, there was a potential for jail time behind that. Since then, and plus now, there just isn't the room in juvenile institutions for that level of offender. How you hold juveniles, when they're in custody, they can't be within ears, eyes of adults. So you have to keep them separate. When you're doing booking and you're in a busy, small jail, Class A facility, I believe, Class 1, and there you can't have, keep people overnight. So you're moving people around a lot, and so it could be really tough to do the booking process with that. And that, caused issues in the courts. So the other really important thing is to know that in the juvenile system, probation, because probation officers run juvenile hall and juvenile facilities. Probation officers in the trial process are really important. They're a key player of what we'll talk about, I believe, next week, which is the courtroom work group. You have the usual cast of characters that are there, but also make sure you put in that probation officers. Now, when it comes down to how the process goes, a lot of different names are used. Juvenile gets arrested, or the police file what they call in Orange County a green sheet, which is the color of the petition. Files a petition with the juvenile court, or with probation, I should say. it gets reviewed, as does in the case of a juvenile arrest. The arrest report is kind of tough because juvenile hall wanted arrest reports within 24 hours. So let's say you end up involved in some big mess of a crime as an officer, in some big mess of a crime at midnight, and you go off duty at 3. Well, you might not be able to get your reports done. So you may be there till 6, 7, 8 in the morning, writing reports that go with the petition, that go with the juvenile, that go to juvenile hall, where the intake processing is done, sometimes called an initial hearing. And the probation officer will look at that and then make a decision just based on that, whether or not it's something A, juvenile courts are going to pursue, B, if they are, what do we need to do with this juvenile? And then make a decision there. And is that juvenile fit for juvenile hall? Now, once that's done, then the next thing is the detention hearing. Kind of like an arraignment. At the detention hearing, you got to find out what you're going to do with the juvenile. But that also includes, are you going to do pretrial custody? Meaning hold on to him until he goes to trial. And you see that basically only in the most serious violent felonies. Then from there, you have an adjudicatory hearing, adjudication hearing. And the adjudication hearing is whether they determine whether or not the juvenile is a delinquent and falls into the purview of the court. If the juvenile does, meaning they're guilty, then it will next have a disposition hearing. The disposition hearing is the judge's decision on sentencing, which is also based significantly on the recommendation of the probation officer, who has been with that case since it was initially filed. So there's also, finally, a discussion about crime control model and due process model with the courts, the juvenile courts. I'd take a good look at that. That's another one of those policy things that if you get involved in that system as an attorney, or maybe working for the DA's office or for the public defender's office, and as you move higher through that system, these kind of policy decisions are going to come to you as to which direction you want your agency to go. Okay. Last thing is, you have your paper topic due this week. I gave you several topics to choose from. If you got something else you like, please, I'm open to it. Send me an email and then submit it per the instructions if I approve it. I'll try to turn those around within a few hours or a day, just if I can. And then you could start, working on that kind of deal. I see insanity pleas, plea bargaining all the time, tons of them. So you got to come up with something really special to catch my eye, and for it to not just seem like a C paper because it doesn't do any analysis. It's more of a report on that. So you got to be really careful. Avoid the report. Do a research paper. Okay. With that said, I believe we have beaten this horse to death, and I will. I'll see you probably not till the next video. Tuesday I'll have office hours from 10 to 11. Maybe a little bit shorter because I've got some things in the OC I have to do, but in that day. But if you want to, pop in, say hi. I'll try to do a pop-up office hours this week too.